The U.S. Constitution is a document that at least most in the United States are aware of as existing and as being the foundation of law in the United States, at least. However, in school, most of us are taught that if you have a legal or law-related issue, that you have to go to a licensed individual, an attorney or lawyer, and therein lies the problem with why it appears that, well, it's one of the main problems at least, why it appears that the Constitution is actually not followed. And in taking a look at this, we should go first to USC, which is the U.S. Code, Title 18, which is Crimes and Criminal Procedure, Part 1, Crimes. And then we'll go to Chapter 13, Civil Rights. And the two sections that we would look at specifically is Section 242, Deprivation of Rights under Color of Law, and Section 241, Conspiracy Against Rights, or 241 and 242, respectively. One of the things that these U.S. codes do is they provide specifics about how a lawful entity is to punish specifically these certain actions. And it also codifies what these actions are. However, both of these titles are operating off the basis of a particular clause in the Constitution. So, according to govinfo.gov, under Section 241 of Title 18, Chapter 13, Civil Rights, Part 1, Crimes, quote, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise of enjoyment of any right or privilege secured to him by the Constitution or laws of the United States. So it's interesting that it says Constitution or laws. That would probably relate to laws underneath the Constitution, but again, all laws are supposed to be canons of the Constitution, so that's kind of interesting. However, there are other laws that are not specific, delegated to the Constitution, and in the Constitution it says anything not delegated is left to the people. And in continuation, or because of his having so exercised the same, or if two or more persons go in disguise on the highway, or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. They shall be fined under this title or imprisoned not more than 10 years or both. And if death results from acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. There you have the death penalty. And again, these codes are supposed to be canons of the Constitution. So anything that is put into a code that is not constitutional is not law, basically. Then, well, that's it's not constitutional law, at least. It may be law practiced outside of the Constitution, but it wouldn't be constitutional law, and the Constitution is supposed to be the main document of law in the United States, at least. And then in Section 242, Deprivation of Rights under the color of law, it states, quote, whoever under color of any law, statute, ordinance, regulation, or custom, notice custom, it's like a traditional practice or something customary, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such persons being an alien, or by reason of his color or race than are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year or both. and if bodily injury results from the acts committed or violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosive, or fire, shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the act committed in violation of the section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years or life, or both, or may be sentenced to death. Now, the important thing about these two codes and the title is that the wording they use is not the same wording that's used in the Constitution. However, all of these codes and titles are canons of the Constitution, and so in order to find where these titles and codes are derived, the easiest thing, of course, is to go directly to the Constitution. And these two codes mainly relate to the clause that covers three things, and that is life, liberty, and property. And all of the things talking about in the code is deprivation of rights, of those three specifically, without due process. So, what is due process? Well, first, let's go ahead and look at the clause, which will, in fact, tell us what due process is. Under the Fifth Amendment, it says no person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. That immediately voids the idea of a bench warrant, because a grand jury has to do it. Of course, if the bench warrant is done with a grand jury, then it would be constitutional. However, we'll get into that later about constitutionality as far as something being executed by a officer, of which a judge would be, and whether or not that person would be constitutional, according to the Constitution, of course. Except in cases arising in the land or naval forces or in the militia, and in this context, militia means not the National Guard, but the entirety of military force as it relates to the Constitution. That's anybody that can be called up to serve on behalf of the Constitution, and at least according to the Constitution itself, that would have to be somebody who swore an oath to the Constitution. And in continuation, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That's usually referred to as double jeopardy. Nor shall be compelled in any criminal case to be a witness against himself. And now here's the last part that is the basis for quite a lot of court cases and is the reason for those two codes. And that says, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. And these passages are taken from the Library of, or Congress.gov, their, not Library of Congress, but Congress.gov, their section on the Constitution. And let's go ahead and look at one important part of the Constitution. And it basically tells us who we can go to when we find that something has been violated. And it is very specific. In Article 6, that's V1, yeah, that's 6. 1V is 4, if I get that correct. It states, quote, all debts contracted and engagements entered into, well, that's not really important for our purposes, at least. At the bottom of Article 6, it states, the senators and representatives before mentioned, and the members of the several state legislatures, and all, note it says, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any officer or public trust under the United States. Now, what that tells you is that if somebody is acting under the Constitution, but they have not sworn an oath to it, they're acting under the color of law. And they have no authority to do whatever they're doing. Also means that going to somebody who is licensed but has not sworn an oath to the Constitution would have no responsibility nor desire to uphold the Constitution, but they wouldn't have a responsibility to. It's that oath that binds the responsibility. So if a judge is not sworn to uphold and defend the Constitution, then they really have no authority to be a constitutional judge. They're a judge of something else, but they're not the constitutional law, at least. And it would be the same with police officers or really any, because this states all executive and judicial officers, which of course could even include teachers and basically anybody who retains a position as an executive of the government or a judicial, because it states, again, all officers. But it's interesting that it also specifically stipulates the senators, representatives, and members of several state legislatures. Those are, of course, are legislative officers. So it is interesting that it doesn't technically specify that legislative officers have to be sworn to oath or affirmation of support of the Constitution, but does specifically state that executive and judicial officers do. So, but not legislative officers, unless, of course, they're a senator, a representative, or a member of the several state legislatures. And it doesn't quite identify what a member is. One of the other annoying things is that the Constitution does not technically define what a jury is, but it does state, or at least on the congress.gov website, it states where the jury is supposed to be taken from. Something else interesting in the Constitution that would be very applicable is that under Section 9 of, I don't remember which article it was, but anyway, it states that no bill or attainder or ex post facto law shall be passed. Ex post facto means after the fact. This specific section removes the validity of the 14th Amendment, because the 14th Amendment restates the 5th Amendment and would constitute an ex post facto law as far as the Constitution goes. And this would be solidified by another section which talks about how no one section of the Constitution can be used to disparage another section of the Constitution. So that's specifically referring to the issue of one law canceling out another law and making those laws not valid because of basically chicanery. And that's in the 9th Amendment, also before the 14th. So, again, you have precedent and whatnot. But it states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And there's many amendments that do that specific thing, which of course means they're violating the other sections of the Constitution and aren't valid. Now, getting back to our context of crimes and deprivation of rights, Section 2 of Article 3 states that the trial of all crimes, except in cases of impeachment, shall be by jury. No one else can try a crime. Only a jury can. And again, it's very irritating that the Constitution Well, the original might have defined what a jury is, but either way, this one that's available on Congress.gov does not define what a jury is. But it does state that only a jury can prosecute crimes, essentially, no trial of all crimes. So prosecutor is not constitutional. However, a prosecutor could theoretically be considered a judicial officer carrying out administrative duties, but we'll get into that later about what exactly a prosecutor and a lawyer and attorneys are. They are, in practice, representatives. The judicial officers of attorneys and lawyers and prosecutors and whatnot, they're representatives. They represent one side or another, and there is nothing in the Constitution that stipulates that a representative is allowed. So, but it again doesn't delegate it, so technically, according to the clause that rights are left up to the people, it's up to the people whether or not they would want a representative. But it does stipulate a counselor anyway. In continuation, and such trials shall be held in the state where the said crimes shall have been committed, but when not committed within the state, the trial shall be at such place or places as the Congress may by law have directed. And under the Sixth Amendment, it states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Again, that's a public trial by an impartial jury of the state and district wherein the crime shall have been committed. So that immediately specifies where the jury is to be drawn from, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That assistance of counsel has been construed or has been explained to mean prosecutors and defense attorneys and lawyers and whatnot. And those are representatives. Well, at least perhaps not the prosecutor, but the defense attorneys and lawyers and whatnot, they fall under that part, assistance of counsel. But they, in fact, aren't counselors if they're representing. That's not a counselor. But it says that you have the right to the assistance of counsel. So you have the right to be counseled on your defense, essentially. But again, it doesn't immediately void the ability to choose to have representation. But that's where it comes in that you can choose to represent yourself pro se, which means for self. And as it pertains to this jury that we're talking about, the constitutional jury, it states in the Seventh Amendment that all suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States. So that's saying that if a jury has tried a case, it cannot be re-examined. And if it is, it's obviously not constitutional, because the Constitution is specifically barring that type of activity. Whether it's agreed with or not, it's in the Constitution that you can't do that. So then according to the rules of the common law. And then it's in the Ninth Amendment that says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And that's where you can't have that canceling out argument that's often made, usually when corrupt people are attempting to obfuscate the laws. And there are at least reported to be examples of such things happening with the laws of the old Mongol Empire, where certain religious edicts or whatnot were construed to be canceled, or to cancel out other edicts, and in protection of the current religion in the time, of course, as we've seen many times with ignoring the Constitution. But again, most of the people that have ignored the Constitution were not bound by oath to the Constitution, so they don't really have any responsibility. They just essentially pretend to follow it. Nothing else. Another part of the Constitution that's interesting, in Section 10 of, well, I'm not sure which article it is, but it says, quote, "No state shall, without the consent of Congress, lay any duty of tonnage, keep troops, or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay." And in that context, we get a understanding of why a lot of state governors have been reported to have repeated the invasion, as far as especially considering the acts on the southern border, the alleged ones. Arizona comes to mind. However, that requires Congress. So let's go ahead and look at Congress. Again, they have to swear an oath to the Constitution, otherwise they are not constitutional, whoever they may be. At least all executive judicial officers, and specifically members of Congress and legislatures. Now, if they swore their oath, then that means they can be bound by the Constitution. And one part of the Constitution they can be specifically bound by is Article 3, Section 3, which defines treason. Now, it states, "Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort." Now, there's 4 things basically listed in there. Levying war doesn't have to mean physical, but it could mean engaging in propaganda campaigns or some sort of action of warfare. It doesn't have to be physical necessarily. And then adhering to their enemies, that could be actually be abiding by laws that are not constitutional. And of course, this is treason, so this would have to be relate to somebody who is specifically bound by the Constitution, or somebody who could commit treason. Theoretically, a foreigner, for instance, couldn't commit treason. But as far as adhering to it, could also be relating to treaties. Giving aid and comfort, on the other hand, that could relate to an event like Operation Fast and the Furious, when weapons were provided to enemies. That's treason. Doesn't matter what the explanation is, but according to the Constitution, it's treason. It does not provide for explaining why adhering and giving aid and comfort was done to an enemy. It just states that doing that is treason, whether or not it was for one reason or another. And it does state, though, that no person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. And that could naturally be taken 2 ways, but that's very specific about what you need to have in place. Open court today could mean many ideas. Of course, open court in this context likely is referring to a constitutional court, and not, say, somebody posted something on Instagram, but it has to be a confession and open court of a constitutional nature. But then 2 witnesses, same overt act, well, if somebody posts something online that could be considered treason, well, then they can, as many people will be witnesses to that. Theoretically, of course, with things online, there's a lot of doctoring and whatnot, so that wouldn't be exactly helpful. But if you had two people that were in the vicinity of an action being taken and they were impartial, or, well, it doesn't specify impartial, but if they're witnesses to the act, then that would suffice, according to this text. And then that Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. In the second part, it's really interesting because Congress has the power to declare the punishment of treason. So what do you do if Congress are the perpetrators of the treason, such as all the endless spending bill packages and whatnot, and those things find their way into the hands of enemies and all this other stuff? Well, they would have to ascribe their own punishment to themselves. And, well, that's likely to go well. But that's the Constitution anyway, about this context. Now, as far as this idea of all of Congress being involved in treason, there is one section, not specifically talking about punishment, but it does relate. Now, under Section 6 of Article 1, we get some context to recent events in this decade, like mainly the year 2020. And this pertains to the charge of treason against members of the Congress. Now, naturally, according to the Constitution, if the Congress has to punish or determine their own punishment, that's unlikely to go anywhere. However, they can be arrested. In Section 6, it states that senators and representatives shall receive a compensation for their services, to be ascertained by law, and paid out by the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. Now, of course, this, for me at least, brings up the idea of the constant sitting that the Congress was doing or reported to have been doing in the year 2020. Of course, I wasn't there, so I couldn't confirm it personally, but it was reported that they were constantly sitting all the time, and this section of the Constitution would give a context to that as them attempting to avoid arrest. However, they can be arrested for those exceptions that were listed, whether or not they're sitting or doesn't matter where they are, really. So, and then there's other things. There's quite a lot in the Constitution specifically relating to representative senators and things that they can't do, which most of them have done, but it's likely that if they did swear oaths to the Constitution, that they didn't particularly care about it if they were engaging in such activities, such alleged activities. Of course, I can't confirm anything myself, so I wouldn't really be able to say one way or the other. Simply observations. In Section 6, the same section, of course, in the next paragraph, it states, no senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States. That could be argued as an appointment to a committee as being an appointed to civil office, and therefore a violation of this section of the Constitution, because committees are not the original position that they were elected to, and it's stating here that they cannot be appointed to any other positions, any other civil office. So that's interesting. And it states, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. That's barring any of the lateral movements and all that stuff that seems to happen, and often you'll find with members of legislatures and stuff that they completely ignore this section and appear, at least, to be members in different offices and whatnot. That would take some more evidence and verification to clarify, though. Now, something else that the Congress is supposed to do, and if they're made up of members that don't care about the Constitution, wouldn't do, of course, one of their charges is to provide for the calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. So if the Congress doesn't care about the Constitution, they're not going to provide for the calling forth of the militia. And there lies a possible reason why we don't have militia marshals or any of the methods that are supposed to be in place for calling the militia forth. And they always like to point out and say that the National Guard is the militia, but it's not, because that's not custom or practice or tradition of what a militia is. It's not the National Guard. And then this, of course, relates to the well-known Second Amendment, which states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And there you basically have a definition for what the constitutional militia is, which is the people, basically. Of course, there's been a lot of argument about that. Naturally, to the benefit of the corrupt that probably haven't sworn oaths and don't have any care for the Constitution, or they're just traitors, possibly, or something else. So, and then in the Fourth Amendment, we get the constitutional warrant and what that is specifically. And it states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And of course, in this context, we should go back to that other part and understand that anybody carrying out these warrants has to be sworn to defend and protect the Constitution. So whether or not a police officer has probable cause and is supported by this section of the Constitution, but they haven't sworn an oath to the Constitution, they are not a lawful constitutional officer or of executive officer, and can't be doing whatever they're doing. They can't be serving any warrants. They can't be doing any of that if they have not sworn the oath. And then, of course, this is very specific about how the warrants are supposed to be derived and what they're supposed to do. Well, actually, it does not very specific about where the warrants are derived from. Although, going back to the grand jury, you'd probably imagine that a constitutional warrant is supposed to be served by a jury. But this section does not specifically stipulate that. And then finally, in the 10th Amendment, it states the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So there we get a general idea of what the Constitution is, and the reason why there's so much issue around it and why it appears that it's not being enforced. Because the people that are supposed to enforce it have to swear an oath to it. If they haven't sworn an oath to it, then they have no authority to carry anything out under it. And that creates a dilemma and an issue that is particularly difficult for most today. And if it's to be fixed, things will have to be properly conducted in a constitutional manner and it to be upheld. And of course, anybody who swore an oath to upheld and defend it would have a responsibility to do so. But if the oath hasn't been sworn, there is no responsibility. But it would be in the best interest of all people that live in the nation to, or at least in what is specified as the territory of the constitutional law, it would be in the best interest, even without the oath, to uphold it, because it's made for the benefit of the people. It's not made for the benefit of any officer or any representative or anyone who operates under the Constitution, whether fraudulently or otherwise. It's not made for them. The Constitution is made for the people, and it would be the people who are ultimately responsible for it, for themselves, essentially. Although, of course, naturally, anybody who swore an oath to it is not going to be freed from that.